Our office gets many calls from across the United States with a fact pattern or similar story consisting of an employee who's been in a hostile work environment. And the employee will usually say, for the last 6 months or so, I have been in a terrible hostile work environment and I've been harassed by my employer. And what our intake specialist will do, Chander, will get a general picture of what's going on, okay? The employee will list many horrible things that happened to them. And what our office does is we send out a table, a harassment table for the employee and prospective client to fill out. And the table basically requires the person to put in the dates of when these incidents occurred, who was involved, who witnessed the incidents, did the employee report it, and most importantly, the specific incident that the employee considers to be hostile or an act of harassment. And many of these calls do result in some good cases, as employees will send back a pretty detailed table. But there are times when we get employees who simply send the table back and they'll write something like, between October of 2015 and October of 2016, there were numerous incidents of hostility. My supervisor insulted me. I was taken off work details, etc., etc. Okay, well, Mr. Client, you have to tell us each and every one of those events. This is the whole thing. These are the methods in which a judge and a jury employ to get to, did you have a sufficiently legal hostile work environment? Now, that's not the way many people think, and we're kind of trained not to do these types of things. And it's certainly understandable that you're in an emotional time in your life. But if you can just understand what the legal process is all about. Generally speaking, I mean, if you take a look at, let's say, anyone with kids who's read the story of Cinderella, and I have 4, and I've read this story probably 250 times, I would think. And you get the story, yes, there's an evil stepmother, and the evil stepmother treats Cinderella really, really horribly, and she treated her own daughters a lot better, and she wouldn't let her go to the ball, and at the end of the story, Cinderella takes the ultimate revenge against these people and is picked to be the new queen or princess or whatever it is. Okay. I would bet that if you took 1,000 parents over the 50 states in America and you asked them to name 15 individual actions that this evil stepmother did to Cinderella, and whether they were witnessed and whether Cinderella reported them to anybody and who was involved and specifically when they occurred within that time period, I don't think you could find one who could tell you. I mean, first of all, in the story of Cinderella, we have absolutely no idea how long this story took, whether this was over a month, a year, 5 years, and there are different versions of it. And that's pretty much one of the hallmarks of fairy tales. I mean, we don't want to bombard our kids with all kinds of legal technicalities. I mean, the point of the story is so that your kid will have a good feeling that the good guys win at the end, and now I can go to sleep without any sort of fear of anybody harming me. That's pretty much the point of the story, okay? That is not what lawsuits are all about. Lawsuits are not about telling some general story to a jury that's going to evoke all kinds of sympathy. Now, that's a part of it. But that's only at the very, very end once the case has cleared all the legal obstacles. And to clear all the legal obstacles, every single one of these facts has to be analyzed. It has each story, each incident is an incident of its own. And Generally, there has to be some method or some thought as to how that thing is going to be proven. So we do ask clients on hostile work environment cases to fill out these tables, because this is the very information that's going to serve as a filter as to whether this case is going to make it to a jury, in which case we will be able to tell the story more broadly and make it more appetizing and easier to digest, or not. Remember also, and this is very frustrating, I know Chander has expressed this to me, is sometimes some people will ask some questions, they will have their complaints of harassment and hostile work environment. We'll send out a table, we'll hear from these people months later, and at that point, there are limitations issues. You only have 300 days from the date of the last incident to file a claim with the EEOC. And if you're a federal employee, you only have 45 days to go to your EEO office, unless it's a age discrimination case, in which case you would have 180 days to complain to the EEOC. And you have to remember that, yes, emotional elements, we certainly get that. And these cases are emotional, and I'm a very intense guy. For people who know me, and my clients will tell you that. But there are limits to that. I mean, this isn't necessarily psychotherapy where a good psychologist can take repressed memories from childhood and kind of reprogram or rewire your mind to think in good ways. Once these deadlines are missed, in law, that's called you lose. So you don't want to ruin your case by not acting on things as soon as possible.